SJC-12277, Commonwealth via juvenile.
Thanks.
Good morning, Ms. Newsom, is it?
Yes, thank you, Your Honor. Good morning. May it please the Court. Eliana Newsom for the Commonwealth. The Commonwealth is asking this Court to vacate the dismissal of the youthful offender indictments in this case because the rape of a dog with sufficient force to cause her intestines to fall out of her body involves this infliction of serious bodily harm in violation of the law, and that is all that Chapter 119, Section 54 requires. At the outset, I want to state that the Commonwealth is not intending to address the arguments made by the Amici Juvenile Defender Clinic and Juvenile Law Center in their brief, as those arguments and that issue is not before the Court, and we have moved to strike that. As to the issue that is before the Court, we argue that the plain language of the statute is determinative in this case.
Wouldn't the plain language be that it's a human? I mean, when you read a statute, I don't think that the first time through, you're thinking it could be an animal.
Respectfully, I disagree, Your Honor. I believe the Court generally looks at statutes as, what would the reasonable person setting out on a course of conduct, reading the statute, would they understand that this course of conduct is prohibited? So if you were considering this conduct at issue here, you would read the statute. Am I a juvenile between the ages of 14 and 18? Yes. Is the offense, would it be a felony if I was an adult? Yes. Does this offense involve the infliction or threat of serious bodily harm in violation of law? Well, we have the animal cruelty law. We have the bestiality law. And I think that
those statutes don't come under generally the crimes against persons.
That's correct, Your Honor.
And every definition I've seen of bodily injury or references to body in statutes tends to be within something in that chapter or does refer to you. This would be a first.
I don't think this would be a first, Your Honor. There is the restraining order statute, so that's Chapter 209, Section 11C. That does recognize that there can be a threat to a petitioner's domesticated animal, a threat of serious bodily injury.
But don't they reference the domesticated animal in those cases? They don't just, you're asking us to read this in when there isn't a reference to an animal, right? That's different, isn't it?
Sure, that specific instance is different, but I think your point, Justice Seifer, is very important because the legislature considered just such a limitation to violations of Chapter 265, crimes against the person, which do require and do often specify, a crime against another, against an elder, against a family member, and they do indicate in Chapter 265 that the victims are people by those terms. So here, the legislature considered a limitation to crimes against the person under Chapter 265 and deleted that language. It struck that language. It chose to have a more strict statute to hold juveniles, violent juveniles, accountable for their crimes in a more broad sense.
Was that to avoid limiting themselves to things that were actual crimes against a person, or that, as opposed to serious bodily injury that might not be charged for some reason? You wouldn't have to be charged to meet that serious bodily injury, right?
Right, the offense, it doesn't have to be an element of the offense that's charged. That's correct. Right, we don't have a great record, a great legislative history as to the exact reason that language was struck and this other language was placed in there.
Even without that history, haven't we read the YO statute pretty strictly?
In some cases, yes. I think not in all cases. And as I mentioned in the reply brief, the Carter case comes to mind as a case where the defendant was arguing for lenity in that case and was arguing, you're doing something you've never done before. And this court said, maybe we're doing something we haven't done before, but lenity doesn't need to apply because this falls within the statute. And that's, I think, an important point. Just because two sides disagree about what a statute means obviously does not create an ambiguity that requires the application of lenity. There's disagreements all the time. If you have two good lawyers, you should have a disagreement about how the statute should be interpreted in those kinds of cases. The ambiguity only exists if after you apply statutory construction principles, after you look at the legislative history if needed, there's still an ambiguity. There's still, the vexing choice that this court faced in Samuel S., where the statute just didn't make sense either way you wanted to read it. And so in those instances, the court errs on the side of the juvenile, errs on the side of the defendant. But I would argue that is not the case here.
I think you say that serious bodily injury for animals is violent animal cruelty, is that right?
That serious bodily injury to animals.
Is violent animal cruelty. I'm just trying to figure out where you draw the line. Is that all animal cruelty?
Right, absolutely. All of animal cruelty would not constitute serious bodily harm. There are instances, animal cruelty involves a wide swath of conduct. It includes tormenting an animal. So you could imagine a case where you're tormenting an animal, but it's not necessarily resulting in serious bodily
Couldn't
harm.
it also include underfeeding, starving, failure to provide medical care?
Correct, overworking.
Hoarding, all sorts of categories of.
Right, and those would not necessarily, the question always comes back to, whether the conduct at issue involves the infliction of serious bodily harm. So there would be circumstances where animal cruelty fit, and there would be circumstances where it didn't. Just like this court has found there are circumstances where rape involves serious bodily harm or threat, and there are circumstances where it doesn't. And that's what the Commonwealth is asking here, that the court read the plain language of the statute, read that there is no addition of words to a human in the statute, and apply it as written.
I mean, there's nothing in the way of legislative history that sheds any light on this, is there?
Right, there's, as counsel points out, there is no mention of animals in the legislative history. But what I would like to point out is that there's really no mention of any particular type of victim. The legislature was concerned about the juveniles here. It was concerned about violent juveniles. It wasn't particularly
Well, I
concerned.
mean as to anything having to do with any statute relating to bodily harm, where the phrase is used bodily harm. I mean,
Bodily harm as opposed to bodily injury is not a common phrase.
And don't take this the wrong way, because the offense conduct is incredibly disturbing and difficult to read. But what about hunting and fishing? And how does that play into it?
So those would not be included under the animal cruelty statute.
Well, it's bodily injury to an animal, correct?
Right,
That's
so
the purpose
again,
of hunting.
the youthful offender statute is very helpful because it layers various levels of discretion, but even the plain language itself, the offense needs to be a felony if the person was an adult. So fishing would not be a felony. So there's a number of places where you might be thinking about the parade of horribles, but when you look back to what all the requirements are, you realize that those actually don't end up being implicated because there are all these layers of discretion and various requirements.
Now, in 1996, when the Youthful Offender Act was passed, was there any felony that applied to animal cruelty?
So animal cruelty itself was not a felony in that year. However, this exact juvenile in that year could have been charged as a youthful offender for this offense because of the bestiality statute. So again, it's not a statute that always would involve
But
serious
that would
bodily
not,
harm.
doesn't apply now? Is that what changed?
So the change was that animal cruelty became a felony in 2004.
Right, but you said that under the bestiality statute, he could have been charged with a felony in
Right, even back then.
1996.
He still, to this day, can be, but I'm saying that this
Okay.
particular case, even in 1996, when this was enacted, there was a form of animal
Charged with
cruelty.
a felony right now.
Right,
was
so
he
this
charged
form of,
with bestiality and animal cruelty?
yes,
So he was charged with both,
correct.
yeah.
But because both were deemed to be, to an animal, the juvenile court
Then he
judge,
could have been charged for bestiality even then.
as a youthful offender, even then.
Okay.
But right now, in this case, is that part of the youthful offender charge?
Yes, that was one of the indictments that was dismissed.
And that would survive the serious bodily injury, even if serious bodily injury was dismissed?
The youthful offender portion does not survive because the judge, in this case, the juvenile court judge, found that the statute does not apply when an animal is the victim. He added to a person to the language of the
Right,
statute.
but the bestiality statute still would be a felony. But he
Correct.
you said he would not be a youthful offender?
Right. So it would be a delinquency proceeding.
And does the rule of lenity apply toward interpretation of youthful offenders?
The Commonwealth in its brief concedes that it likely does under, after the Watts case, because it does increase the potential punishment for a juvenile by potentially subjecting him to adult penalties.
So
I don't think that case.
If we are unclear as to whether or not the legislature intended this to be limited to humans, then you'd lose.
If after applying all of the statutory rules of construction and looking to legislative intent, if you decide to apply the rule of lenity, I expect that we would lose in that case, Your Honor. But in that case, I believe that is a miscarriage of justice and of the legislature's intent, and I would ask this court to clearly delineate in its opinion for the legislature why the statute is defective and does not capture that conduct if this court.
But just to be clear, and going to Justice Gaziano's point, it's not that he walks free if you lose. He just would be adjudicated in a juvenile court.
In this particular case, that's true, Your Honor. I would ask the court to consider the circumstances that do regularly apply as well, where somebody commits such an offense at the age of 17, a complaint issues, let's say the youthful indictment also issues, but if the youthful indictment is not allowed to proceed, they can plead to the delinquency complaint immediately upon arraignment, face a month under DYS supervision, and then they're out again. And I don't think that that is serving the legislature's purpose of rehabilitating these youth. I don't think it's helping these youth either who have committed these very serious.
We never consider that circumstance when we look at the YO statute, right? We never consider the punishment. I mean, that's not really before us, is it?
I think as far as the policy considerations, it can be considered.
I mean, the amicus raised some very valid points about the disturbing nature of this conduct and what it says about a juvenile and ramifications for the future, but that's not before us, is it?
Right, I guess my point is that the Commonwealth argues that its interpretation here is in line with, for example, Section 53 of Chapter 119 or the Hansen H decision. We're not arguing for this overly punitive reading, and this interpretation is in line with the goals of the juvenile justice system, including the goals of caring for juveniles who commit these very disturbing crimes. They are better served when they are able to have treatment for an extended period of time and have services for an extended period of time rather than being released into the adult world, most likely reoffending and then facing up to 7 years now on the animal cruelty charges or up to 20 years on the bestiality charges. That was my only point with respect to that.
Can I ask one question on the rule of lenity, and maybe a naive question? He clearly knows he's engaging in some criminal conduct here. Do you need to know, if you know it's criminal, does the rule of lenity apply? You don't need to know the specific crime, do you? Or does that matter when you're interpreting the rule of lenity? So he knows he's engaging in some type of criminal behavior, but he doesn't necessarily know this thing because it's ambiguous. So is
Right,
that
I don't think he needs to, he doesn't need to know that he is going to be a youthful offender. I think the idea is he would need to know, had he read the statute.
What I mean is, does the rule of lenity apply when you know you're engaged in criminal conduct? You just aren't drawing these types, you don't know what particular crime you've committed?
No, the rule of lenity doesn't apply under those circumstances, Your Honor. It's more if you...
So if he knows he's engaging in animal bestiality or whatever, it doesn't matter that he doesn't know this youthful offender issue, so the rule of lenity shouldn't apply then?
Well, the rule of lenity is less about the individual's actual knowledge than his knowledge were he to read the statute. So were he to read the youthful offender statute, would he be on notice is the standard? Would he have reason to believe that his conduct was captured? And the Commonwealth argues he would very well know that what he was doing involved serious bodily harm in violation of a law. And that's all that's required.
That's all. So in your view, then, the rule of lenity wouldn't apply here because of that, because he knows he's engaged in criminal behavior.
Right, and the plain language of the statute is enough to put him on notice that this sounds like it applies. Maybe my creative defense attorney
That part, you lose me on that part. You see, my question is, is it just enough that he knows he's engaging in criminal behavior? Because I find the statute gets murky, and I'm trying to understand if the rule of lenity applies when he just knows he's engaging in criminal behavior regardless, sort of generally.
Yeah, my understanding of the way the rule is generally applied is as the as a statutory construction unless with respect to his individual knowledge.
Okay.
Okay, but I'm trying to understand. I thought you told me earlier that you had conceded that the rule of lenity would apply
That the rule of lenity would apply,
here.
no, not that it would apply here, that it would apply in general to the interpretation of the youthful offender statute if
Yeah,
There
I'm
was a
sorry, I know.
re-
You
if there
say
was a
that, the
resounding
rule of lenity does
ambiguity.
not apply because there's no ambiguity. But
Correct.
if there were ambiguity in the youthful offender statute, not going to whether or not the act is illegal, but going to whether or not it is a juvenile adjudication or a youthful offender adjudication, is it your view that if there is ambiguity, the rule of lenity does apply?
I believe that is true under Watts, Your Honor, but that issue has not been squarely decided yet.
You said, but Watts didn't decide it? I mean, I haven't gone back to look at Watts, but,
Not in the youthful offender context, but I do
okay.
believe that it talks about when penalties would be expanded to a juvenile, so it seemed on point to the Commonwealth.
okay, thank you.
Thank you very much.
Mr. Faulkner?
Mr. Chief Justice, and may it please the court, this question is not about what is the correct policy. This case is about whether the legislature clearly and unambiguously put the juvenile on notice that a crime involving serious bodily harm to an animal would indeed trigger the provisions of the youthful offender law. I think the Commonwealth does get it right. The youthful offender law can be looked at, in a sense, as an aggravated penalty. There are additional elements which have to be proven beyond a reasonable doubt to a jury. That it's a felony, that he's between the ages of 14 and 17, and that it's an offense that involves the threat or infliction of serious bodily harm. So the underlying crime in and of itself involves one set of elements. This is an additional element which triggers much expanded penalties. So to Justice Kafker's question, I would suggest the rule of lenity applies to the youthful offender statute, which is in and of itself an aggravated crime.
So even if he knows he's engaged in criminal behavior, it's obvious, the rule of lenity still applies because there's ambiguity in this statute, right?
That's correct. And in this very case, there were pending delinquency proceedings. Those proceedings remain pending. But
And does that, can I just, I haven't read Watts, or at least I don't remember reading Watts. Does Watts answer that question about the rule of lenity, or you don't know either?
I don't know either. The Commonwealth cited Watts in their reply brief as part of their concession that the rule of lenity applies. So I'm not sure whether Watts specifically says that, but I would suggest that in the case where we have greatly increased penalties, it is a case where the rule of lenity applies. Because in a sense, the youthful offender statute is what makes this a crime versus the non-criminal juvenile delinquency system.
I'm a little confused here. So would the juvenile, on your view, have to be put on notice that his conduct would constitute the underlying crime, or that it would constitute bodily harm?
What he was not put on notice of by this statute, I would argue, because it's ambiguous, is that his crime involved.
Crime or his conduct? Don't we look at his conduct?
In order to meet the element of youthful offender, yes, but I think the youthful offender statute in and of itself can be fairly looked at as a crime. In other words, there are additional elements that need to be proven beyond the elements of bestiality, beyond the elements of animal cruelty. There are additional elements that need to be proven to prove somebody a youthful offender. So it's the youthful offender crime in and of itself of which he hasn't been put on notice. And that's the problem here. The legislature, the Commonwealth seems to have conceded at argument. It's spent a fair amount of time in its brief arguing, well, the purpose of the youthful offender system is to punish juveniles, but there's absolutely nothing in the history of the youthful offender statute that indicates in any way that it intended to focus the statute towards animal cruelty. The Commonwealth speaks to how the history at one point involved a limitation to Chapter 265, and Chapter 265 is entitled Crimes Against the Person, and a great many crimes against the person are contained in Chapter 265, but there are other crimes against the person that are codified outside of Chapter 265. So I would suggest the legislature, even intending to focus the statute on crimes against the person, a limitation in Chapter 265 would prevent it from going forward on other crimes that are contained outside of Chapter 265. An example, I think, could be witness intimidation, which is in Chapter 268. Witness intimidation is a crime which is a felony and could involve the threat or infliction of serious bodily harm, but is not under Chapter 265. So the simple removal of Chapter 265 doesn't mean that the legislature intended to expand the statute beyond persons to animals. It would be very simple. The Commonwealth asked for the court to, in its decision, to make very clear to the legislature what it is that's wrong with this statute. It's pretty obvious that the only amendment that needs to be made is that it could be amended to say serious bodily harm to an animal or a person, or to a person or an animal. And that's precisely what the legislature did do in Chapter 209A. In, I think it was 2016, they amended the statute to include the threat or infliction of serious bodily injury to a domestic animal. There are several, currently under the general laws, the only references to bodily injury, and there's no references to bodily harm, the only references to bodily injury come in Chapter 265. Subsequently, the 209A was amended to include serious bodily harm to animals. Throughout the Commonwealth's brief, it cites to laws in other jurisdictions which talk about substantial or serious bodily injury or harm to animals, but in each of those cases, the law specifies that it applies to bodily injury to animals. That's what we don't have here. The statute just says substantial bodily harm. And I would suggest that that isn't enough to put particularly a juvenile, and we have to remember this statute is focused on juveniles, so we're not even talking about the read that an adult would have, to put a reasonable juvenile on notice that his crime, in this case, involves substantial bodily harm to a non-human. If there are no further questions, I would rest on the brief.
All right, thank you.
Thank you.
And we'll take our morning break.
All right.